नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Is this part understood to you? The part which I explained. क्या नहीं समझ में आई? आप बताइएगा। आप ये वो है, आप डॉक्टर के पास गए हैं, अपना मर्ज नहीं बताइएगा तो कैसे पता चलेगा?
Sir, I have a doubt.
Yes, please.
Sir, so we're on the third stage, and we say that the Indian rules to private international law tell us that for succession to movable property, the law of domicile applies, and that means the Italian law of domicile.
Yes.
Sir, then we talk about the question of whether internal laws of Italy apply or whether private international rules of Italy will apply.
Wonderful. Yes.
Sir, why is this question asked in the first place? I'm asking this only because if we stopped at saying that, okay, the internal law of Italy applies, then that would be the end of that.
Yes.
And I feel like this brings in a layer of complication, but I don't know why that complication has arisen.
That's one of the reasons why almost every scholar is fascinated by doctrine of Renvoy, and they talk about Renvoy passionately. Of course, I mean, and this fundamentally, I mean, why they are passionate about doctrine of Renvoy is something very much similar to what you explained. That why complicate it further? For the simple reason that private international law rules of Italy, for example. Now you have followed the stages very clearly. Say that question of jurisdiction is decided, is an Indian citizen, Indian courts are looking into the matter, and Indian private international law rule says that, law of domicile should apply. Now, as per law of domicile, the matter would be sent to, say, Italian. Or not sent, but would be Italian law would be referred to in deciding the matter. Now, as you rightly said, just apply Italian law and then we are fine with it. This is a general practice. That is what happens. Most of the courts do it. But certain jurisdictions, they also recognize or acknowledge what has been recognized as doctrine of Renvoy. Why they do it? That is the question which you have asked, Manvi. They do it mainly because they say that what if Italian court had a jurisdiction in this matter? What if Italian court was deciding the same issue at hand? In such a situation, an Italian court would have referred to its own private international law rules. And when they would have referred to its own private international law rules, the private international rules might have said that, law of nationality should apply to decide the subject matter. Then the Indian law would have applied in relation to the same issue on which Italian law is being applied by the Indian court, for example, or the British court, for example. It is this complication which brings to the fore doctrine of Renvoy. It has the potential to maybe reinforce forum shopping. That the parties would sit and decide that, let's go to Italy, because in that situation, Italy will refer to its own private international law rules and then say that, Indian law should apply. And then they will apply the Indian law and then say that, fine, we are very happy with the entire process because we wanted Indian law to be applied. So that is the point which becomes very central when we are talking about doctrine of Renvoy. And it is for this reason that they invoke doctrine of Renvoy. It is for this reason precisely that they said that we should have something called doctrine of Renvoy to, say, limit the pathologies of such selection of forum shopping. Are you getting it, Manvi? Is it better now? Can you understand the problem?
Fairly better.
Okay. What is the problem? Tell me. I mean, anyone who has a problem, please share. We will try to solve it to the extent possible. Yes, what is the problem?
Sir, because to me it seems that if the private international rules of Italy are applied and they say that the law of nationality will apply, then we go back to applying the internal law of India. Not internal law of India, but the law of nationality of India, because these are Indian citizens.
Okay.
It almost seems like a unnecessary back and forth. I'm not able to...
Yes. My God. This is precisely what the criticism of doctrine of Renvoy is. Why complicate it so much? But is there a possibility of some kind? But do you understand the exact problem? That there is a possibility that depending on the forum you approach, different laws might apply. Do you acknowledge that problem? Only that part of it. Manvi, you are still here?
Yes, sir. That's clear. Yes.
Oh, that's clear. Fine. So at least to that extent, we are on the same page. Any other questions? Shubham, do you have any questions? If you don't want to speak, that's perfectly fine. Just type it in the chat box. Both Shubhams. Fine. Two Shubhams are together. So both Shubhams. You have any questions? No, yes. We have already heard from Manvi. Sakshi, is everything fine? Are you following the discussion? No, yes. Manu?
Sir, I suppose further clarity on this subject will be gained only once we attempt to define what is Renvoy in the first place.
Okay.
Right now, we've just understood the need for defining Renvoy.
Yeah. So but otherwise you have understood the problem, right?
Yes, sir.
Yeah, fine. I mean, we are going step by step because we cannot complete everything. Now it becomes too technical for everyone. Tushar, is it fine?
Yes, sir.
I mean, the problem is understood, right?
Yes, sir.
Yeah. Donika?
Yes, sir. Sir, just one thing. In this last answer that you had given to Manvi, you just mentioned forum shopping, but I could not really understand the entire concept of it. Like, how did it affect the doctrine of Renvoy, and like how does it affect the entire problem? So, could you please, please explain that again or something?
Yeah. Now, okay, fine. Let me also hear from Amisha and then we will club all the questions if there are any. Amisha? You can also type if I'm perfectly fine with that. Alright, maybe. Now, what we are actually referring to is a situation where, say, parties make an evaluation that, you know what, I mean, different forums might apply different law to solve the dispute at hand. So if private international rules of one country would apply, then, say, matter would be decided by Italian law. But if private international rules of another country is applied, then the matter would be decided by Indian law. Now, after making an analysis as to which law is more favorable, a particular forum can be approached. When we say a particular forum can be approached, the situation which we are looking at is that the forum which is more favorable to the party which is seeking the remedy in the case at hand. Now, this fundamentally reinforces that there is a selectivity in the entire process as to which forum to choose, and depending on the legal loophole which is there. The legal loophole, not in a strict sense, but maybe more in terms of how one forum might benefit the party more than how the other forum would benefit the party. We had a small discussion on forum shopping when we were talking about the issue of jurisdiction as well. So this application of different laws, the possibility of application of different laws, provide a window of opportunity for the party to the dispute to say approach or to prefer one forum over the other. This selectivity, this choice, which depends on the possible or the probable conclusion, reinforces the idea of forum shopping. This is what I meant when I refer to that point. Now, if you understood this point, then we'll go back to Manu's concerns. Of course, Manu's concerns are bigger here, that no, let's actually try to understand the entire situation and then come to the point whether we have understood or not. Now, what is the question which I asked was what is meant by Italian law in the example above? Now, does it mean only the internal law or also includes rules of private international? Now, there are three different solutions or three different approaches to the entire issue. The first approach is relatively simple, something which both Manu, Manvi and others try to identify. That, you know what, all that matters is apply the substantive law, apply the internal law, and then just finish the matter. Why are you worried about their private international rules? Now, The second is, however, the second solution is known as single renvoi, or the doctrine of single renvoi, or which is also known as partial renvoi. And in simple sense, renvoi is translated as remission. What do we mean by remission here? That imagine that if a judge in country A is referred by his own rule of private international law to the law of country B, but say the private international law rules of country B refers such a case to the law of country A, then the judge which is deciding the case in country A would apply its own internal law to solve the dispute. I know it is complicated. Let me explain it. Let's take the same example which we were looking at. That, say, a British judge or an Indian judge, the example which we do, say a British judge, for example, an Indian judge is looking into the matter, and private international law rules relating to succession to movable property say that law of domicile should apply. And they refer the matter to, or for example, they refer to the Italian law to solve the dispute at hand. Now, the first solution was that just apply substantive law and then solve the dispute. Now they don't do it. They say that no, let's go and solve, let's also look at the private international law matter at hand. And when they look at the private international law rules of Italy, they say that, okay, private international rules of Italy basically says that the law of nationality should apply. If that is the case, then the matter comes back to, say, in our example, say the British court or the Indian court example which we took. Hypothetically, of course, since India does not recognize, so let's talk about British court. Now, then they will apply their own law to solve the matter at hand. Then they will apply their own domestic law. So a British judge would apply the law of Britain to solve the dispute at hand. This is known as remission. The remission, what is it? What is being remitted here? That the matter bounces back to the forum country by virtue of application of the private international law rules of the country, which was identified by applying the rules of the forum. So the matter bounces back from there and comes back to the law of the forum again. And that is how the disputes are solved. I will do it again. Maybe I will do it for the last time and then I will ask again if you have understood what is partial renvoi or remission or single renvoi. These are the same names given to the same idea. We are looking into a situation where, say, a British court is deciding a situation where a person whose nationality is British, but he was domiciled in Italy, where he passed away, and then he left certain movable property in Britain. Now, the court is looking into the matter. The first step is that court being satisfied about jurisdiction. So, whatever the laws are there, court is satisfied about the question of jurisdiction. The second stage for the court is to say that how do we classify this issue? Fine, court classifies this issue as a matter relating to succession to movable property. Then court looks into the private international law rules of Britain to say that, you know what, according to our private international law rules, the law of domicile should apply. Court said that what is the domicile of this individual? He said that when he passed away, his domicile was that of Italy. Court refers to the Italian law. Now, in general situation, in most of the situations, the Italian substantive law, internal law is referred to, and the matter is decided. But in such a situation, when we talk about application of renvoi, then private international law rules are also referred to within the idea of, say, Italian law. So Italian law is not just about substantive law, it is also about private international law rules. That is the fundamental presumption on which renvoi is based on. Now, the British court would refer to Italian law, including private international law rules of Italy. And looking at private international law rules, the British court realizes that, you know what, law of nationality should decide who should succeed to the movable property of the deceased person. Now, what is the nationality of the person? British court would ask. And British court would say that, you know what, it is Britain itself, and therefore they would apply the law of the British. There's a very simple way of explaining it, that a British judge would step in the shoes of Italian judge to decide the dispute at hand. This is, in a very simple sense, this is the terminology which is often invoked in understanding doctrine of Renvoy. That a British judge would step in the shoes of Italian judge to decide the matter at hand. Say that, okay, fine. I mean, let's look at Italian rules of private international law. It refers to the law of nationality, and then law of nationality is, say, Britain, and therefore British law should apply. This is known as single renvoy or partial renvoy or remission. Is this point understood now? To put it in more simpler sense, if you really want me to put it in definitional sense, then it means that a reference to the law of a country does not only mean reference to say a particular kind of law, that is substantive law or internal law. Rather, reference to the law of a country shall mean reference to the whole body of law or whole of its laws, including its private international. That's like a very simple way of putting what is the basis of single renvoy. सिर्फ renvoy मत बोलिएगा, क्योंकि एक अभी double renvoy है, उसकी तरफ भी हम लोग आ रहे हैं. That's even more complicated. I mean, that's a bit more complicated, not even more. Cheshire is extremely unhappy with renvoy, and when I was reading him yesterday, he said that this is a famous but regrettable doctrine. So that not a proper doctrine, but it is such an important aspect that every student of private international law must know about it. What is renvoy and what is double renvoy? Abhi baat samajh mein aayi aapko? If there are any questions, I would be happy to hear.
Yes, so basically in this in the case of single renvoy, the court comes a full circle and back to the original position. I mean, when they apply into the private national law of the another country, and they find out that it's basically their law which should be applied, their own law. So basically, they come a full circle. And if I have summarized it in a correct manner, if not, please correct me.
Yes. So it's like throwing a ball on the wall and then catching it back. So so if I'm playing with a cricket ball, I throw it on the wall and then it comes back again. There's something like this. A judge is deciding the dispute at hand, applying its own private international law rules. It refers to the laws of the foreign country. It realizes that it's not just substantive law which we should refer to, but also the private international law rules. And referring to the private international law rules of that country, the judge believes that no, it refers back to the law of my own country, for example. And therefore, the judge applies its own laws to solve the dispute at hand. Donika, you summed up.
Yeah, all right. Thank you, sir.
Excuse me, sir.
Anyone?
Sir, I suppose what Donika's interpretation right now is it is just a coincidence, or is it universally applicable that you revert back to the law of your own country when you apply partial renvoy? Because I suppose it is just applicable, it is just becoming true of the present circumstances of this case, wherein we are talking about Britain and Italy and matrimonial laws of both the countries.
Yeah.
Or is it like universally true that partial renvoy always necessarily means reverting back to your own country, what you said, throwing the ball on the wall and getting it back?
No. So, yeah, that's a very good question again. Now, it might happen that when court would apply their own private international rules, court would say that, you know what, private international rules of Italy would apply. Now, or the Italian law would apply. And court gets into analysis of private international rules of Italy. And court decides that no, Italian private international rules also agree with the point that Italian law should apply. So if Italian private international law rules also says that yes, domicile of the deceased person should apply, then apply Italian law. That's the end of the story.
So it's not universal, it was just coincidental that the
That remission means coming back. And there is another and I'm going to complicate the situation which Donika was trying to create. What about a situation where it refers to the law of third country? What if private international law rules of Italy does not say that law of nationality should apply, but law of habitual residence should apply. Just imagine, hypothetically. Then a country C would come into picture. A being Britain, B being Italy, C being, say, Spain. वैसे situation में क्या होगा? That is known as transmission. Remission and transmission. Manvi, you have something to say.
Yes, sir. So, as an aside, maybe we can take it up after we are done with this whole doctrine.
Yeah.
Especially in terms of partial or single remission. So, how does this? How do we resolve this with the issue of sovereignty? Because, to my mind, it almost seems like we are saying that the Indian Court of Law will apply. Will adjudicate as if it was the Italian Court of Law.
Mm-hmm.
And I would like to know if there are issues of sovereignty that can be brought into the picture when we are talking about this doctrine.
Okay. Manvi, just to, as you rightly said, maybe we can have a longer discussion on this aspect. And the question which you asked, I think that is true for entire private international law. The moment we refer to, say, the jurisdiction or maybe the laws of another country, say that, okay, it has to be applied in one way. The only way to solve such issues in terms of applying a foreign law in a dispute at hand is by the rationale of Comity of Nations. That is how courts have justified it. So for all the cases which we'll study throughout the semester, and there are too many, you'll find that court refers to the idea of Comity of Nations all the time. Court says that no, it is not, this is not erosion of sovereignty that we are talking about. What we are actually doing is that we are trying to do justice. We are trying to reinforce the rights and obligations of the parties. It has nothing to do with how India as a sovereign state stands. That's one reason which court identifies. In terms of maintaining sovereignty, you also have certain exceptions of, say, public policy, whether the court did not have jurisdiction or whether it is violative of certain laws in India. So all those gaps, I would say, I don't know, important gaps in the sovereignty are filled by the exception clause of enforcement and recognition. So yes, that part is there. But to put it in a very simple sense, Manvi, I would say that they explain such practices with the help of idea of Comity of Nations. Of course, some of them are critical of Comity of Nations. Say that Comity of Nations might not be a very, very sound basis of private international law, but it is generally accepted. It is generally accepted. Comity of Nations is generally accepted as a basis of private international law, although many are critical of it. That's all I would like to say at this point of time.
All right, thank you.
When you say that Indian judge should step into the shoes of Italian judge, that does not mean that Indian court would declare that, at least for the purposes of this case, we are Italian court. No, there would be an Indian court, but they will be using this particular doctrine to maybe, and the stepping into the shoes aspect is often used to explain the idea of doctrine of Renvoy. It is not a formal declaratory stance that, okay, we are going to declare that we are Italian court for the purposes of this issue. That would have been interesting, though.
Okay, thank you, sir.
Yeah. So, yes, Manu, please.
To add to the issue that Manvi raised, can we also quote Cheshire when he says that the fact is that the application of a foreign law implies no act of courtesy and no sacrifice of sovereignty. It merely derives from a desire to do justice.
Thank you so much, Manu, for maybe putting it in a better way through Cheshire. Yeah, this is precisely what it is. Yeah, but I'm open to a larger debate on this issue. In fact, I'm more than open to a larger debate on this issue. The Bakshi has a wonderful piece on private international law and how its rules are to a large extent problematic. But maybe this is not the occasion to speak about it. But is this part clear? Something which I have explained today. ये बात समझ में आई आप सबको? मानवी, मनु, तुषार, डोनिका, अमीशा, साक्षी, शुभम. Tushar?
Yes, sir. Clear so far.
Oh, wonderful. I'm very happy. Manvi, yes. Shubham, are you there? Both Shubhams. Oh, nothing. Okay. Okay, Donica is fine. It looks fine. Yeah, Shubham, you want to say something?
Yeah, actually, this clash of mine, this class clashes with one of my regular classes. Most of the time, I'm able to get it done, but today I just had to tune in and tune out because of some presentation.
That's all right. That's perfectly fine. That's perfectly fine. If you have any problems, maybe you can contact me in the evening. I will try to explain it again to you.
Sure, sir. Thank you so much.
Right? I will not overburden you with any more concepts today. I mean, with the help of Donika's summarizing, I have already explained the idea of transmission. Transmission is a situation where, say, in the same illustration we were looking at, the British court looks at its own private international law rules, says that Italian law would apply, and instead of looking at Italian substantive law, it looks at both substantive law and the private international law rules. And then after looking at the Italian private international law rules, it says that no, it is the law of Spain which would apply. That is the, say, habitual residence, for example. This hypothetically. Then the British court would apply the law of Spain to decide the matter at hand. This is known as transmission. I'm almost expecting a question, a very funny question, but something which was asked to me in the last in the last semester, and we laughed for almost 1 full hour because of that question. But that's perfectly fine. Maybe I'll give you 1 full day to think of that question, and we can laugh together in the next lecture. Thank you so much, all. I mean,
That is also partial renvoi.
sorry, this is not transmission.
So that's double renvoi or partial renvoi only?
We have not yet come to double renvoi. Yeah, no. So it's a separate concept altogether. It's a separate concept altogether. It's like remission, transmission. So these are 2 different concepts altogether. Together, all these things are known as renvoi. In specific, this back and forth part of it is known as partial renvoi or single renvoi.
Back and forth part of it as in transmission or remission?
Remission. Back and forth, when I'm saying back and forth, it means British court referring to Italian laws. That is remission.
Is partial renvoi and transmission is not single renvoi.
Not considered in that sense single or double. There is a specific term for that transmission. Although if you really want me to have a look at it, I will in fact go and see if there are any technical words for that too. Transmission is the general word which is often used for such kind of situation. Is that fine, Manu?
Yes, sir. Thank you so much.
Yeah. But you have understood the concept, right? All of you, remission and transmission. So today we talked about these 2 concepts called remission and transmission. Okay. Okay then, I don't know. Fine, bye. Yes, Tushar?
No, I was just going to thank you, sir.
All right, fine. We meet tomorrow or whenever we are supposed to meet as per the schedule. Yeah.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।